The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, thank you for joining us today. We'll start our webinar in about another minute or so. Thank you. Okay, good afternoon everyone. We're going to go ahead and start our webinar. Thank you for joining us today. My name is Erin Oshiro and I am the Director of Immigration and Immigrants' Rights at Asian Americans Advancing Justice AAJC. Today is the final webinar of our three-part summer webinar series on immigration enforcement. Immigration enforcement can be a complicated issue, but it's something that we should all care about because it impacts our civil and human rights. We hope that by providing more background and context about our immigration enforcement system, what it is, who the actors are, and how it impacts our communities, more community members will be encouraged to engage in efforts to reform the system for all immigrants. Today's segment will focus on the entanglement of state or local law enforcement in federal immigration enforcement activities. State and local cooperation with federal immigration enforcement can take a couple different forms, but for today we'll just be focused on two programs, Secure Communities and the Priority Enforcement Program. This webinar will cover what these programs are, why they are problematic, and how communities and advocates have been engaging on this issue at the state and local level. For today's webinar, I'm really excited to be joined by Saira Hussain, a staff attorney for the Criminal Justice Program at Asian Americans Advancing Justice Asian Law Caucus in San Francisco. Saira's organization has been a longtime leader on this specific issue, and we're very fortunate to have her today. Our presentation will take approximately 25 to 30 minutes, and then after the presentation, we will have time for Q&A. We will be using the questions feature on the webinar to collect your questions. So that's in a box on the right-hand side. So feel free to submit your questions that way, and we'll be monitoring that. And I'll repeat that again when we get to the Q&A part. Because so many of us have joined today on the webinar, all participants will be kept in mute for the duration of the webinar to minimize interference and background noise. Just two more housekeeping notes. We are recording this webinar and we will post it online afterwards for your reference and to share. And lastly, the information presented today is just for information purposes only and doesn't constitute legal advice, and unfortunately we will not be able to answer specific legal questions about specific individual cases you may have. So without further delay, I will start us off by explaining what Secure Communities and the Priority Enforcement Program are, and then I will turn it over to Saira to speak about advocacy on these issues. So we'll start with Secure Communities. What is Secure Communities? Launched in 2008 by President Bush, Secure Communities was a Department of Homeland Security run through Immigration and Customs Enforcement, or ICE, that was created to identify immigrants in jails who were deportable. Unlike other programs that you may have heard of, such as 287G, Secure Communities, or SCOM as it was also called, allowed DHS to have a technological presence in local jails rather than having to physically deploy federal agents to state and local jails. Ultimately, a little more than 3,000 jurisdictions were covered by secure community, so it had a tremendous reach. How did ESCOM work? When an individual is booked into jail, his or her fingerprints are sent to the FBI to be run against criminal databases. Under ESCOM, the FBI also sent the fingerprints to Immigration and Customs Enforcement, or ICE, to be checked against immigration-related databases. If the person got a match in an ICE database, meaning that the person might have an immigration violation, ICE and the local police would be notified of the match. ICE would then determine how to proceed with respect to that individual. Often, ICE would issue what is called a detainer or a hold, which was a request to the local law enforcement that they voluntarily detain the individual so that ICE could decide if that person should be transferred to federal custody rather than being released when they would otherwise have been released. Detainers are just requests. They are not warrants issued by judges based on probable cause, and Syra will get into a little bit about why that is very problematic. ESCOM proved to be very effective at increasing rates of deportation, and it's estimated that as a result of secure communities, nearly 400,000 individuals were removed after being identified through the program. So now we have something called the Priority Enforcement Program, or PEP. Again, Syra will sort of address the criticisms and the problems with secure communities, but as a result of a lot of advocacy from community members, advocates, and even law enforcement themselves in some cases, DHS announced last November, as part of other announcements on executive action, that it would be terminating secure communities and replacing it with something called the Priority Enforcement Program, or PEP. Like ESCOM, PEP continues to engage local law enforcement to help federal immigration enforcement officers in the removal process. One change from ESCOM is that PEP is intended to be more targeted and to focus on individuals who have been convicted of specific offenses. One of the criticisms of ESCOM was that it caught people who had not been convicted and really weren't priorities for enforcement, that it just sort of got people at the front end of the system who may not have had any criminal history. So who is a priority for PEP? PEP has narrowed the categories of individuals that it will prioritize. So they're focusing on people who have been convicted of some specific offenses. And to understand PEP, you have to look at an additional policy that came out in 2014, which is called the Policies for Apprehension, Detention, and Removal of Undocumented Immigrants. So I don't want to get too technical here, but basically there are 6 categories of individuals that are identified as a specific priority for PEP. The first one is, and these priorities are found in the other memo that's referenced here. So priority 1 is someone who has been convicted of engaging in terrorism or espionage or is otherwise a danger to national security. Priority 1C is for a person who has been convicted of an offense for which an element was active participation in a criminal street gang, or a person under not younger than 16 who intentionally participated in an organized criminal gang to further the illegal activity of the gang, so people with sort of gang-related issues. Priority 1D are aliens convicted of an offense classified as a felony in the convicting jurisdiction. Priority 1E is an individual who has been convicted of an aggravated felony as defined in federal immigration law. An aggravated felony is a very specific term of art that we covered in our last webinar. The other 2 priorities are priority 2A, which is a person who's been convicted of 3 or more misdemeanor offenses. And then the last one is someone who, priority 2B, is someone who has been convicted of a significant misdemeanor, and those are defined more specifically in the memo. So the stated purpose of PEP is to be more limited in who it might reach. And I should mention, though, that in the PEP memo there is also a catch-all that says that a person could be a PEP priority if, in the judgment of the local ICE field director, that a person poses a risk to national security. So that is vague and potentially problematic and could catch more people than otherwise covered in the memo. But how does PEP work? So it's similar to secure communities that in the beginning, basically people have their fingerprints taken when they're booked at a state or local jail, and then those fingerprints are turned over to the FBI and run against ICE databases. And if a person has a match, then ICE has to determine now if the person meets the specific enforcement priorities for PEP that I just went over. If the person does fit one of those specific PEP priorities, then ICE has two options. They can issue a request for notification, which basically asks the local jail to notify ICE before the person is released, or in more limited circumstances, ICE can still issue a request for a detainer, but only if the person is both a PEP priority and there is probable cause to believe the person is removable. And probable cause could be something such as a final order of removal or some other indicia of probable cause that the person's removable. Detainers will only be for 48 hours and cannot exclude weekends or holidays, which is what could have happened under secure communities. The PEP in its material says that most of the time people will be subject to requests for notification, and that is what ICE is moving toward, a system of notification rather than detainers, and that the detainers should be fewer than we have seen under secure communities. But I think that really remains to be seen. The next slide here just kind of summarizes the key differences between secure communities and the new PEP program that I just went over. So, PEP has only been implemented very recently, and we don't yet know what it will look like or if there really will be a meaningful difference between secure communities and PEP. We know that the Department of Homeland Security has been actively engaging with local law enforcement to get them on board with PEP, because many jurisdictions, as Syra will describe, declined to participate in secure communities or put in place policies that prohibited them from participating. But now DHS is really sort of trying to sell PEP and get more jurisdictions on board and participating in the program. So I am going to turn it over to Syra now to talk more about the problems with these programs and what advocates have been doing. Syra, I think you might have to unmute yourself.
Oh, okay, great. Can you hear me?
I can hear you.
Okay, great. So first off, thank you so much to Erin for leading us in this webinar and to AAJC for hosting. This is such an important topic, and so much of the work that we do here at Advancing Justice Asian Law Caucus has to do with ICE and local law enforcement. So I'm happy to be here today to talk with you all about this, these new programs and what ICE entanglement with local law enforcement looks like, as well as the pro-immigrant policies that we've seen in various jurisdictions. So, as Erin was mentioning, there are some serious concerns about local law enforcement's entanglement with ICE. So there's both legal reasons and policy reasons for being concerned about this entanglement. So under the legal arguments, one of them is about 10th Amendment and federalism concerns. So the Supreme Court has held that the federal government cannot commandeer local resources in order to carry out the federal government's job. So one of the serious concerns that was taking place back when ESCOM was there, and before different jurisdictions found out that the detainer requests were voluntary, is that ICE wasn't very transparent about it. They were trying to wiggle their way around the issue. But using these 10th Amendment arguments, we soon discovered that detainer requests can only be requests, just as notification requests are nothing more than voluntary requests that local law enforcement is not obliged to respond to. Because as I mentioned, the federal government cannot commandeer local resources. And I know that right now, Erin will speak about this later, but there's pending legislation in Congress talking about how federal funding pertains to so-called sanctuary cities, or actually jurisdictions that do not necessarily comply with all immigration detainers for reasons relating to due process and Fourth Amendment violations. So this is one thing to keep in mind, that the federal government can never commandeer local resources to carry out their work. The other argument is related to racial profiling. We've seen across the board that it's not uncommon for U.S. citizens or non-deportable non-citizens to be caught up in the secure communities dragnet. There was a report that was released in 2011 that found that something like 1.6% of individuals who were detained in detention facilities were actually U.S. citizens, non-deportable. And several, hundreds of these people were actually deported at some point too, erroneously. So this shows that not only are there serious problems around the accuracy of these databases that ICE uses in order to identify people that may be deportable, but there's also a racial profiling component where they're likely identifying people based on last name, based on perceived ethnicity or perceived racial race. So it's also very concerning, and things that people locally should be monitoring in their areas. And then, of course, there are policy arguments related to why ICE should not be entangled with local law enforcement. Of course, it fosters distrust between immigrant communities and local law enforcement if local law enforcement is acting as immigration agents. It also undercuts community policing, of ensuring that people in the community feel safe coming forward to report when they're a victim of or witness to crime to their local law enforcement agency. And it also makes immigrant communities unable to separate local law enforcement from ICE. So once again, you have huge swaths of our population who are unable to approach local law enforcement if they just see them as one and the same as ICE. Next slide, please. Great. So with these ideas in mind, and with the concern about building that trust between local law enforcement and immigrant communities, there was a 3-year campaign in California that was, really a testament to grassroots organizing, especially among undocumented youth population. So it's known as the Trust Act in California, and what it does is it disentangles local law enforcement from immigration. It prevents local law enforcement from holding individuals for extra time based on these immigration detainers, or otherwise known as holds, and it really limits in which circumstances local law enforcement is able to do that. So it was a 3-year statewide campaign. It gained a lot of momentum, and a lot of different groups came together to speak out about why we needed this law. It was finally signed into law by Governor Brown in October of 2013, and it became effective January 1st, 2014. So we're a little bit past 1.5 years into the implementation of this act. Next slide, please. So like I mentioned, the Trust Act prohibits local law enforcement from detaining individuals in response to ICE hold requests and for most minor offenses. And if an exception applies, and there are several exceptions to the Trust Act, local law enforcement may respond to the hold, but it's not required to. So really the Trust Act is a statewide floor, not a ceiling, and local jurisdictions can go beyond the act to ensure greater protections for its immigrant community. Next slide, please. One before, please. So on the heels of the passage of the Trust Act, there were actually several very strong federal cases that came out about immigration holds, and it shed more light on what these holds meant, and also whether these holds were complying with constitutional protections. So in the first case, in March 2014, Galarza, the Third Circuit held that ICE holds are voluntary and not mandatory. And like I mentioned, ICE had not been very clear about this prior to this case. In this situation, Lehigh County had detained an individual who was not deportable. He was actually a U.S. citizen. And they tried to avoid liability by saying, well, ICE sent us this form. We had to comply with it. We were required to. And the Third Circuit held that no, ICE holds are not mandatory, and therefore local jurisdictions will be held liable when an individual is detained erroneously, even if that error comes from ICE rather than the local jurisdiction. The second case, Miranda Olivares versus Clackamas County, was in April 2014, and that was a federal district court in Oregon that found that ICE holds violate the Fourth Amendment because they're not based on a probable cause finding. So these holds, as Aaron talked about, they do not have any probable cause on the face of the hold itself. What it usually states is that ICE suspects that the individual may be deportable, or it says something like the ICE is investigating whether the person is deportable, which does not constitute probable cause. And moreover, these holds are not signed by judges. Rather, they are signed by deportation officers, so there's no independent judicial review. And like I mentioned before, because of the fact that this Secure Communities program, and now we suspect PEP as well, is such a large dragnet program that actually captures individuals who are not deportable into the system, it creates an even stronger argument for having judicial review built into the process, which ICE has failed to do. So, on the heels of these two cases, we then sent out, along with many other organizations in California, a letter to California sheriffs and county councils about the new cases that had come out, as well as the Trust Act. And we informed them that if they were to hold individuals erroneously, or if they were to detain individuals without having the requisite probable cause to do so, then they would be opening themselves up to liability. And essentially, that's what ICE was doing. ICE was putting these jurisdictions to take on the liability while they were just the ones sending out these detainer requests that were unconstitutional and didn't comply with the Fourth Amendment, but were leaving the cities and counties to take the blame. So we asked them to follow suit and stop complying with ICE detainers altogether because of all the problems that existed in it. And next slide, please. And very soon after, the counties started to adopt policies of no ICE holds. And what this means is that it goes beyond the Trust Act. So it's not only counties that comply with the requirements of the Trust Act for the specific offenses that the Trust Act requires counties to not hold individuals on, but just no ICE holds, period. So despite whatever charge there may be on the hold, they would not hold these individuals because of all of the concerns about Fourth Amendment protections and ensuring that the community felt safe approaching local law enforcement. So as you can see here, this is the bulk of California. This is the majority of counties. And this list does continue to grow. And it's not only California either. Many of these cases spurred jurisdictions across the nation to adopt no detainer or no hold policies. Next slide, please. So in California, the impact has been pretty stark. In Northern California, the number of individuals transferred to ICE custody between October 1st, 2013 and September 30th, 2014 decreased by 53% compared to the previous year. During that same period, there was a 15% decrease in the 7-county jurisdiction covered by the field office, ICE field office in Los Angeles, and 4 out of the 5 counties that have the largest number of declined ICE holds nationally were in California. So we could see the effects take place almost immediately after adoption of the Trust Act, and then the furtherance of these policies through the case law that came out soon after. Next slide, please. And like I mentioned before, the effect went far beyond California. So as you can see here, there's about 320 total jurisdictions nationally that have adopted policies limiting ICE holds. If you go to the Immigrant Legal Resource Center's link at the bottom left of the slide, you can see which jurisdictions they are, and also there's a map showing how limited the detainer policies are. There's some that do not comply with any ICE holds. There's some that comply with them in very limited circumstances, so you can take a look there. There are 3 states, like I mentioned, that have adopted the Trust Act: California, Connecticut, and Rhode Island. And over 100 of the jurisdictions, of 320 total jurisdictions, do not respond to any ICE holds. Next slide, please. So in response, we have seen not just the priority enforcement program being implemented, and we're still waiting to see exactly what the effects of that program are, but we've also seen the shift in ICE's tactics. So back during the days, actually prior to secure communities, in the early days of secure communities, we used to see a lot of home raids. We used to see people being picked up at home, and that's increased again. Just anecdotally, we have seen a number of people being picked up from their homes, oftentimes on very old convictions, most likely falling into the priority 2 category. So we receive a lot of reports of that. We've also received some really disturbing reports about ICE infiltrating the criminal justice system, where individuals who go in to check in with their probation officers, for example, show up and ICE is there to pick them up and take them into custody. That happened in Stanislaus County, out in the Central Valley of California. In Santa Clara County, we saw ICE pick up an undocumented man when he went to a hearing inside a county courthouse. So we know that ICE still has ways of getting certain pieces of information about individuals, and it really creates fear. A lot of individuals feel like they can't approach the criminal justice system because of fear that ICE will be nearby or waiting for them, as in the case of both probation and this individual who went to report to a hearing. Next slide, please. And like I mentioned, information sharing is not just within the criminal justice system, but it kind of goes beyond that. So in Alameda, which covers areas like Oakland and the entire East Bay of the Bay Area, we saw an individual who was picked up on a drunken public charge and taken to the police station. And while he was there, an ICE agent questioned him about his immigration status, didn't ask him for his home address, but 10 days later, that same agent showed up at his home to take him into immigration custody. So we know that the agent either had access to the booking sheets or the databases that the police department had to find where this individual lived, which is very, very problematic. We've also seen notification, which is kind of the hallmark of the priority enforcement program. There were at least 2 individuals detained for extra time during their release process, so that ICE could come to the jail and take the person into immigration custody. And once again, it raises concerns about racial profiling. There was a case in Los Angeles where an individual who was a U.S. citizen was supposed to be released from custody, but the local law enforcement there demanded to see his birth certificate and actually held him for 14 hours until his sister was able to come and prove that he was a U.S. citizen who was actually born in Texas. And that case was recently settled. There are some serious Fourth Amendment concerns there. Next slide, please. And so, Erin, please feel free to jump in on this, but what can community organizations do to support their respective communities? So, of course, we know that across the country there are various policies in place when it comes to dealing with ICE. Some that may be sort of on the California end of things, where there is law that sets out exactly how local law enforcement has to be disentangled in certain ways from ICE. And then on the other side, there can be complete entanglement between local law enforcement and ICE. One of the most important things to do is, of course, share the information that you know in your local community to inform community members on how to protect themselves, on what their rights are. Community presentations and informal sessions, media briefings, all of that is really important to make sure that the community is aware of what the current state of the law is, what current actions are taking place in their region, and then also on how to protect themselves. Another thing that many groups in our area and in our state have been doing is developing relationships with other organizations doing work around immigrant rights. And oftentimes we have found that partnering together really helps shape what we want policies to look like. So when there's a lot of folks who are coming from different parts of the immigrant rights field, as well as civil rights in general, that really helps shape a lot of the messaging and helps develop those relationships so that there can be a lot of free flow of information between the different organizations. We also think it's really important to engage with local law enforcement and elected officials. Oftentimes, local law enforcement take a very hard line on immigration, or they'll be very friendly with immigration officials because they don't recognize who in their community is really affected by these policies. And so showing them the people who are actually affected and engaging with the community really holds them accountable to ensure that they're not trying to promote really anti-immigrant policies that scapegoat an entire community.
Thanks, Syra. I think what I would add to what communities can be doing, for this last part about your last recommendation about engaging with local law enforcement, I think that's really important, particularly as PEP is getting up and running. So Department of Homeland Security has said that local jurisdictions, can sort of shape what PEP looks like in their community. So, a sheriff's office could say, we're only going to provide notification for, let's say violent criminal offenses, so sort of limiting who they will kind of coordinate with and who they won't coordinate with. But it's not clear yet how those agreements, if you will, or those understandings will be communicated to the community. So it's really important to, as you're saying, Syra, to be in touch with your local officials and local law enforcement, so you understand, what is being discussed, how the program is being shaped, and how you can weigh in and try to shape it and influence it to what your community wants and what your community needs. And the other thing I will add is that, in the wake of recent events and tragedies in a couple communities, including San Francisco, where Syra works, there has been a lot of attention to the issue of, they're called quote unquote sanctuary cities, right, or localities that have these trust policies in place, or policies that prohibit cooperation with ICE or other immigration officials. And certain members of Congress are really using these opportunities, these tragedies to sort of, push very kind of anti-immigrant rhetoric, and really trying to undo all of the work that community members and advocates have done to, push back against these kind of entanglement between local law enforcement and federal immigration officials. So the House of Representatives, just before they went to recess a couple weeks back, or about a month ago, passed a bill that essentially would take away certain federal funds from local law enforcement if they're, not cooperating fully with immigration officials. Basically, it's punishing local jurisdictions that have prioritized, community trust and community policing over cooperating with ICE. It's very likely that the Senate will consider similar bills in September or later in the fall. And it's the important thing about these kinds of bills, I think, is, to really sort of, speak loudly and with one voice about how these are bad for our communities, and to really let our representatives and our senators know that this isn't what our communities want, that these are bad for our communities for a number of reasons that Syra went through. Because I think that, if legislation like this kind of gets passed, then things can sort of steamroll, and all of the hard work that people have put into pushing back on these programs could be undone. So I think it's just really important to kind of try to stay on top of developments and to stay engaged, to the extent that you're able to. I know that people have busy lives and many priorities, but this is one that has really kind of seized the attention of the media and certain members of Congress, and something we're all watching very carefully. Sarah, anything else before we start Q&A?
Yeah, I just wanted to add to your point about keeping apprised of developments at the national level, to the extent that individuals are part of communities or are in jurisdictions where their representative is proposing negative legislation. Then, making sure your voice is heard, speaking out, calling, and sending in letters and phone banking, those are all really helpful to let elected officials know that we don't support these policies. Moreover, I think one thing that really gets lost is that sanctuary cities are not the same thing as no-hold jurisdictions. So what we've discussed this entire time during this webinar was no-hold jurisdictions. Sanctuary cities were started way back in the 80s when the U.S. was unfairly denying asylum to individuals who are from certain Central American countries because of political reasons. And that kind of limits the resources that local governments can spend when it comes to working with immigration enforcement. And the no-hold policies that I mentioned stem from these federal court decisions that show that ICE detainers and ICE's mechanisms for immigration enforcement run afoul of the Constitution. So it's really important to separate the two and not confuse sanctuary cities with the no-hold jurisdictions.
Thanks, Sarah, for some context on the terminology. So we are ready to take your questions. Sarah, we have one question to start, which was, what is your sense of right now of how PEP will interact with trust? Or what do you see as the next sort of how the Trust Act might have to evolve?
Yeah, that's a great question. So, one of the things that the Department of Homeland Security and ICE were saying, so what they did was when they were introducing PEP to local jurisdictions, they went on this road show across the country, and it was the ICE director and the Deputy Secretary of DHS who were going around the country trying to introduce this as like this brand new program that would be great and wouldn't have the same problems as secure communities. And so one of the things that they said was that that the Trust Act trumps PEP. And we were wondering, what does that mean? And quickly they walked back on that. They walked back on it saying that, no, that's not what we meant. And so basically what the Trust Act covers detainers, right? Detainer requests, and because ICE will be doing notification, there will definitely have to be some consideration of how the Trust Act can be evolved to affect notification. There are definitely some ideas floating around that folks are considering, that legislators are considering, and so we hope to bring the Trust Act up to date now with this new enforcement program as well. But I do want to point out that places like Philadelphia, the city of Philadelphia recently defined a detainer to include a notification request because they're essentially the same. When they lead to the same outcome, which is an individual being turned over to immigration, they pretty much are the same thing.
That's really interesting to know about Philadelphia. Thanks for sharing that. Another question that someone submitted is has to go with probable cause for detainers under the new PEP program, and the question is isn't an order of removal or even an NTA too vague to be considered probable cause? Do you have thoughts on that or a response?
Yes, absolutely. So what ICE is saying is probable cause is not necessarily probable cause. So what they're trying to say is the new detainer form has these boxes that say something like, oh, the person has been convicted of X offense, and therefore that's the probable cause that we have. That's not quite probable cause, and I think that that really recognizes that just because an NTA or a prior order of removal is issued, it doesn't necessarily constitute probable cause. So that's something that ICE is trying to claim that they've resolved, but advocates have been pointing out that that's still an open question. And as soon as we see these new detainer forms start to take place and we see where they're issued, they can once again run afoul of the Fourth Amendment.
Okay, thank you. Again, if people have questions, you can submit them with the chat feature on the right-hand side of your screen. Another question that we got, Sarah, is about 287G, and my understanding is that program is still in place and they don't have any plans to change it. Could you explain for a minute what 287G is and the status of it, if you know something different?
Sure. So 287G is another type of enforcement program. What it does is it deputizes local law enforcement officials to act as immigration agents. And so there's usually this memorandum of understanding between ICE and the local jurisdiction where, you know, for example, upon release or something like that in the jail, a local law enforcement official will then act as an ICE agent and interview the individual to ask them about their immigration history. This program never gained that much traction. It wasn't as popular as, of course, Secure Communities or the Criminal Alien Program, or CAP, which is present in many jails and prisons across the country. So 287G, I know here in California only one jurisdiction currently has this program in place, and that's in Orange County. Recently, the LA County Board of Supervisors decided to terminate their 287G agreement with ICE. I think it was back in May of this year, because of many of the problems that resulted, which was, you know, once again, immigration officials, local law enforcement officials are acting as immigration agents. And in this situation, you know, when ICE is when local law enforcement is holding people for ICE, then the community begins to see them as one and the same. But in this instance, in 287G, the local jurisdiction is acting as ICE by then engaging in many of these questions and being deputized to act as ICE agents. So they recognize a lot of the problems prevalent in 287G. From my understanding, I think there's only about, I want to say, between 20 and 30 jurisdictions across the country that actually use 287G.
Thanks, Sarah. We have a follow-up question to the question about probable cause and whether, you know, NTAs or orders of removal were sufficient for probable cause. The follow-up question is, you know, are there successful strategies that people are using to object to NTAs or orders of removal being used as probable cause? I'm not sure if this has come up yet since PEP is so new, but wanted to ask you.
Yeah, I think that we haven't quite seen it yet because we haven't seen the new detainer forms being used. Like I mentioned, the old detainer forms, which I know are still being used in several jurisdictions, we've seen them somewhat recently in various deportation proceedings. Those ones, you know, federal courts have found lack probable cause. They violate the Fourth Amendment. So, you know, we've been able to see the new forms. We haven't seen them in place yet. So I think it's really important for local advocates to monitor and see where these new forms are being used. One of the other concerns about these new detainer forms is that ICE said they're going to be used in special circumstances, but they haven't defined what those circumstances mean. And so the question is it just where they believe they have probable cause, where they can check off one of the boxes, which, like I mentioned, is not necessarily what probable cause is under the Fourth Amendment. One of the things that ICE has also stated is that they may be using them in rural counties where ICE can't get to, where ICE is not able to reach very quickly in order to pick the person up for if they're issued a notification request. So, you know, one of the things to also watch out for is, for example, if ICE sends a notification request but isn't able to make it out there and they follow up with an ICE detainer, that's also very concerning. So, you know, something to monitor, especially in those rural counties where ICE doesn't have much of a presence.
Thanks. Sarah, I wonder if you could speak about some of the advocacy while we're waiting to see if we get more questions that you and Endelon have done with the FOIA request. You guys have engaged with ICE. I wonder if you might speak about that for a minute.
Yeah, absolutely. So we have this great website. It's called The Truth About PEP, so www.truthaboutpep.com. And on that website, what we've done is, in partnership with Cardozo Law School, we have sent out Freedom of Information Act requests to several federal agencies, including ICE, DHS, and many of the agencies that interact with these two major agencies. So back when Secure Communities was taking place, a similar FOIA request went out to a bunch of different agencies. And we eventually had to litigate that request. But ultimately, we received a lot of documents that showed how untransparent ICE was in their attempts to implement secure communities. So there was all kinds of issues that were present, things like the frontline ICE officers not following the directives from the top, engaging in racial profiling. There were tons of different documents, and ICE did not want them to be public. They didn't want to release them to the public. And so we followed up about PEP because we're seeing that this program is being implemented in a similar manner to secure communities, basically under a shroud of secrecy. So keep apprised of this website. As we receive documents, we'll be posting them, and we'll be informing people about what these documents mean. So we're expecting this to happen within the next several months, where we'll start receiving sets of documents. And it's unfortunately one of the only ways to actually find out about what's going on behind the scenes and what's going on with the implementation of the program. Since it was announced back in November, which is about 9-10 months ago, the program purported to be much more transparent, much more humane to secure communities. But I think by the virtue of us not knowing anything about when this program will be fully implemented or in which counties it's currently operating, we're seeing the same mistakes being made as were made under secure communities.
Thank you, Syra. Yes, I think one thing that we have been hearing from DHS and from ICE, is a commitment to more data collection and sharing of that information, and we'll have to see kind of what the quality of that data is, and also how what they choose to share and how frequently, because I feel like a challenge in the past has been that either the data isn't shared or it's shared so belatedly that it isn't quite as useful. So if we're able to get more of that information more quickly, I think will be helpful as we're trying to monitor and track things as they're developing. Sarah, I did want to add a correction. Thank you for noting that earlier when I spoke about who are PEP priorities and went over the different priorities. I said that people had to be, two of the priorities could be someone who had been convicted of terrorism or convicted of certain gang affiliations. And that's not true. They can be just suspected of that. Is that correct, Syra?
Yeah, that's right. So especially around the terrorism one, or the threat to national security, the person only has to be suspected, which of course we know is very, very problematic, especially when we're talking about, for example, the AMEMSA, Middle Eastern Muslim South Asian community, which is still feeling a lot of the after effects from 9/11 surveillance and counterterrorism efforts. And then the gang affiliation one is also very problematic. Across the country, we know that there's areas that have certain gang injunctions. So oftentimes, if you're a certain individual of a certain race congregating in an area that has a gang injunction on it, you can kind of automatically be suspected to be a gang member just by virtue of where you're located or who you associate with. So once again, these major racial profiling concerns rise to the surface. Because both the terrorism and the gang affiliation priority 1 categories are not, it's not necessarily a conviction, it can only be a suspicion.
Thanks for that important clarification, Syra. So I'll do one last call for questions, but while we see if anything else comes in, just wanted to mention some resources. So Syra mentioned, the work that she's been doing. So here we have, if you want to go directly to the source, there's ICE, and you can see what you can find about PEP at their website, and then also truthaboutpep.com. And we'll be sharing some additional resources when we send follow-up materials to everyone who signed up for today's webinar. And if you have more questions, please feel free to reach out to myself or Syra. We'd be happy to provide answers to any questions that you may have. So let me do one last check. So I don't see any more questions in the queue. Syra, any parting thoughts before we close out?
Because we still don't know what this program exactly is going to look like, I think it's really important for local advocates to monitor, see what's going on in the jails, see whether your jurisdiction is signing up for the priority enforcement program and what it's going to look like, and then disseminate that information to your community. It's just so important to ensure that the community knows what's going on, especially because, like I mentioned, this program's implementation is shrouded in secrecy. So we want to make it as transparent as possible and ensure that our communities know how to protect themselves.
Thank you so much, Syra. I really appreciate you joining today and sharing all of your expertise. So this concludes our summer webinar series on immigration enforcement and its impact on AAPI and other communities. I hope that everyone found the information today helpful and useful, and that you learned something that you didn't know before. I think it's a good reminder that there is much work to be done on these issues, and it's through working in solidarity and coalition with one another that we can help advance these issues that are so important to us about protecting civil and human rights. So again, this webinar, like the others, will be posted online, so we'll send that out to everyone who signed up today. And thank you so much for joining us, and have a good week.